divvied up to the seller. All right, so last part of this presentation, which I have about 10 minutes left, I want to talk about some hotline issues. First thing I want to talk about is mortgage fraud. Oh my goodness. So mortgage fraud is a subcategory of financial institutions fraud. It's a crime characterized by some type of misstatement, misrepresentation, or very important omission in relation to a mortgage loan, which has been relied upon a lender. A lie that the bank's decision about whether, for example, to approve a loan, accept a reduced payoff, or agree to certain repayment terms is mortgage fraud. But remember when we were talking about fraud before, we talked about how omission equals lie. It's on the same level playing field. It doesn't mean you have to actually say something that is a lie to the lender, but rather you have some information that may help the lender make a decision and you hold back that information, okay? We are going to be, we're dealing with this issue kind of right now at the forms committee level, because a number of years ago, we took the term amendment off of the ORW. And we did it because the ORW said amendment on it, and there's no justification, reason, argument, defense that a broker could use for why that form wasn't going to the lender every single time. But it wasn't. And what really is upsetting to me is the fact that a lot of times it was the so-called lender, and I'm going to use that in quotes, that was telling the brokers or the buyer, don't send us that document. We don't want to see that document. Now, what you have to remember is that the person you're dealing with on the other side of the desk or on the other line, at the end of the phone, who you think of as the lender, is not the person making the hard decisions. They're pushing paper around, but they're not making the hard decisions. The people that are having to decide whether or not to make that loan or not make that loan are in the back room, right? And they're combing through all of the information that they have available to them, credit reports and all these things that are having to be provided by the buyer and information about the property to make a decision as to whether or not they want to make that loan or not. So when that person on the other side of the desk is telling you, don't give it, I don't want to see that piece of paper, and you're thinking, well, that's the lender, and the lender's telling me not to send the piece of paper over, well, then clearly, that's okay not to send the piece of paper over. But it's not okay not to send the piece of paper, because the reason they don't want you to send that paper over is because they know, or they think, that it will have an impact on whether or not the underwriter, the guy in the back room, will make that loan or not. And going back to this definition on the screen, what is it called when you withhold information, not from the guy across the desk, but the guy who's got to make the decision, or the girl who's got to make the decision? When you withhold that information from that person, what is that called? That's called mortgage fraud. And I can't help what the definition of mortgage fraud is. There's no way I can change the definition of mortgage fraud. I don't have that kind of power in the world. I'm sorry. That is what it is. And so I find brokers being put in this very difficult position all the time because of the lender on the other side of the desk. And I challenge any of those lenders to call me if they take issue with what I'm saying, because it is what it is. I can't, again, change what it is. So we took that word off of that form a number of years ago, and it has created more problems. I was reluctant to do it at the time, and we decided as a compromise that we would push everybody off of that form to deal with any kind of monetary issue, whether it be a seller concession or a price modification reduction, push them off of the form and make them go to an amendment to deal with those issues. But what has come of that is this idea that the ORW is no longer an amendment to the contract. You have to remember that the buyer has agreed to buy and the seller has agreed to sell in the current condition of the property. So when the seller says, I'm going to do certain things, and the buyer says, well, I don't have to buy this property unless you do those certain things, that's an amendment to the contract. That's what it is, right? So if I say I'm going to put a new roof on, or I'm going to put new windows in, or I'm going to fix this, that, or the other, and I don't have to perform as a buyer unless you do these things, seller, I've amended the contract. So we were having this discussion the other day, and we're trying to figure out a good solution for this. But there is going to be some changes to that form, significant changes to that form. And if you look at this form in other states, they're very clear it's an amendment or an addendum to the contract, right? And it's very clear from the form that's what it is. I feel like the brokers have been misled because we took that word off. I had a broker who actually who negotiated a $40,000 check or payment from the seller to the buyer after closing on a property where the buyer was getting a loan. And when I asked them if they had sent that document, the negotiation on the ORW with the $40,000, if they had sent that to the lender. The broker's response was no, because they may not make the loan if they have that document. And, you know, the broker really did make that comment with no understanding that what she was saying was the definition of mortgage fraud. And I said, you absolutely have to send that to the lender. And the buyer actually didn't want to send it to the lender when the brokers realized what had to happen. And to the broker's credit, I'm so proud of them, they were willing to walk away from the deal. And it was a very lucrative deal before they would participate in that. And when, I don't know if it was because of their, what they said they were going to do, or they're just sending them this definition of mortgage fraud that I had sent to them. Ultimately, the buyer found cash, a pile of cash somewhere, and decided to avoid the loan and just pay cash for the property. But the ORW is an amendment, and there's no way around that. Numbers should never be negotiated on that form. Like I said, that's why we push you off, and we don't even have a place where you can put numbers. We say that there may be a seller concession or a price modification, but there's no numbers. The parties can't agree to anything on that form as far as numbers are concerned, because they're not there. We push you off onto that amendment. But even the issue of repairs is becoming an issue with this form. I had one broker actually send it to the lender, and the other broker got on the phone and yelled at them for 15 minutes about how that form is never supposed to go to the lender. Well, the exact opposite is true. It really should be going to the lender every time. And I know nobody wants to hear that, because I know that you're thinking in your head, well, that's going to screw up deals. That's not going to get things done. Buyers aren't going to be able to buy. Sellers aren't going to be able to sell. Lenders aren't going to make any money. I'm not going to make a commission. I've done a lot of work. I know those are the things you guys are thinking. And you can take your upset out on me if you want to, but I'm not the one who created the definition. I'm just the messenger. And there's plenty of cases of mortgage fraud that we can take a look at. And I just want to avoid that. I want to avoid you guys getting in that position. So I want to call it what it is, but we are looking at ways that perhaps parties can negotiate repairs and then come to a conclusion. And then that conclusion may have go to the lender, but the negotiations don't necessarily have to go to the lender. So we're trying to figure out how to do this and stay above board. So you need to watch for those changes. They're becoming in the next 4 months. Online deadline default. I don't know if you guys read my NMAR article that was mailed out on 1/25/22. I was just talking about that voice article. And it talks all about the deadline default, and it talks about when it would apply. And I mentioned it earlier. You have to have a deadline. You have to have a default, right? So not all deadlines are defaults. We talked about waivers, right? If you don't object in a certain time frame, you waive the right to object. That's a waiver. That's not a default, right? So you have to have an actual default. And then deadline, we're using the term deadline, but really what we're probably going to turn that into is curable defaults, because there are defaults of the contract that can't be cured. I like to use the one, and there's not a lot of them, but for example, where we say the buyer's not going to go onto the seller's property, jump over the back fence and peer in the back windows, and unless they have the seller's permission or the listing broker's permission. Well, if the buyer should do that, that horse is out of the barn, so to speak. You can't put it back in. It's already done. It can't be cured. So that's not a curable default. That's not a deadline default. It's just a default, right? But in the event that there is a deadline or something that has to happen by a certain date, or something that can be cured with notice, that's when that 2-day notice needs to be going out. And that would include closing. If you get to the closing date and the buyer hasn't provided a written rejection letter from the lender, or some information as to some financing contingency or appraisal contingency, or something that hasn't been satisfied, they just don't show up for closing, that's a default that you would serve a 2-day notice to for. And I've had some people say, well, what is the benefit of having deadlines if we're just going to give everybody extra time to cure them? And the response is this. I mean, first of all, it's very common in contracts to have an opportunity to cure a default. But if you have an opportunity to cure a default and you give that opportunity and the defaulting party fails to cure it, you have solidified, or at least strongly worked very favorably in the favor of the non-defaulting party to solidify that their action, whatever they do next. So in the event, for example, a buyer doesn't do what they're supposed to do, 2-day notice to cure is sent out, and they don't cure that default, and the seller says, I want to take this other offer over here. It's a better offer. I'm going to move on anyway. I gave them an opportunity to cure. They didn't cure it. The seller's in a much better position to do exactly what they want to do, because they gave an opportunity to cure and it wasn't cured. So it's not just for the benefit of the defaulting party, but to the benefit of the non-defaulting party as well. A couple things on counteroffers, you guys. don't counter expiration dates ever, ever, ever. Okay. So if you get an offer in and, maybe your client is mulling it over and trying to figure out whether or not they want to take it or not, and they notice the expiration date is coming up and they want to extend that expiration date, don't send a counter over to the buyer side, because what happens when the buyer accepts that counter offer? Well, you've extended the expiration date, great, but you've also incorporated all of the terms of the original offer that weren't changed by that counter offer, which are all of the terms of the original offer, right? Except for the expiration date. So you don't want to do that. And that has actually happened, which is why I mentioned that. If you need some more time for the buyer to consider it, the seller to consider the offer, reach out to the other side and ask them to create an addendum. They'll send over the addendum, which will expand or extend the expiration date. And if your seller likes the offer, they're going to accept the offer, they're going to accept the addendum. That's going to be your deal, right? So you're going to have the extension right there on the addendum, and they'll just accept it right after they accept the offer. If the seller is countering, you don't need to worry about expiration dates. Do not worry about expiration dates. They don't matter. It's a brand new offer. You don't need to be worried about the expiration date if there's a counter, okay? And appraisal waivers, which I talked about before, but now we're creating this addendum, which I went into great detail, and I'll be talking about some more in my video if it gets approved. Look for that. So I won't get into the appraisal waiver issue. I just want to remind everybody about the inspection report. The contract provides that you don't send the whole inspection report unless the seller requests it. If the seller requests it in writing, the seller does not have to pay for it, right? The seller should be doing it prior to the termination of the contract, because then you still have the contract in play and you can rely on the language that says the seller has a right to it. Also, who's asking for it? We're going back to transaction brokerage versus agency. Who's asking for it? If the seller wants the copy, because there are some bad stuff about having it. So you as a listing broker should want that in writing anyway, right? Because you don't want the seller getting an inspection report. They don't like what it says in there, and now they have to disclose it to the next buyer and blame you because you asked for it. So you want to get it in writing from the seller that they want that report, and then you could forward that over to the other side saying, here's my seller's request in writing, just as is required by the purchase agreement. Now you need to send it over. And no, we don't have to pay for it because that's not a provision, right? And if they don't provide it, this is very important, you guys. If they don't provide it, because it says upon written request, they will. So if they don't provide it upon written request, what's happened? They've defaulted, right? So you have a buyer who has every right to terminate the contract based on their inspection contingency within the inspection deadlines, right? And then the seller says, okay, well, I do want a copy. And the buyer says, I'm not going to provide you with a copy. Or you have to pay me for it. Again, none of that's provided for in the contract. So that's a deadline default. That's the equivalent of a deadline default, because we say it's going to be provided upon request. That's the time frame for providing it. And when it isn't done, the seller's broker can send over a notification of default, and the buyer has 2 days to send the report over. And if they don't send it over, then they're in default, and that earnest money that they would normally be entitled to, right? Clearly entitled to if they terminated prior to the objection deadline, well, they're not entitled to it anymore. They forfeited their earnest money. So, there are ramifications. I will also tell you this. I've heard brokers say, we have a duty as a broker to disclose adverse material facts to everybody. So if I, as a buyer's broker, have a report that says adverse material facts, I have an obligation to send that over to the seller under my broker duties. Okay, that's a ridiculous argument. I'll just go on the record as saying this. I might be proven wrong, because it's a seller actually went to the real estate commission and filed a complaint against a buyer broker who sent over the report and said that they didn't want the report, and the contract said not to give the report, but they still sent the report over. And so the commission is going to have to wrestle with this. But I will tell you this, there are other broker duties that say that brokers are supposed to do other things. For example, help the buyer comply with the terms of the contract. It says don't send it over. So there's a broker duty too. And then a broker duty that says that you're going to exercise reasonable care. Maybe the seller doesn't want the report. Matter of fact, the seller has said they don't want the report in the contract. I don't send it over to me unless I ask for it. So they've already said that. So I don't know how you give more credence to one broker duty over 1 or 2 or 3 other broker duties. Plus, when you are the beneficiary of a regulation or a statute, you are the one who benefits for it. You have the right to waive that benefit, right? That is the way the law works, right? If a statute is created to protect me and I want to waive the benefit of that statute, I can do that. And so a seller should have every right to waive the right to receive that. And and not receive that document if they don't want it. So we'll see what the real estate commission says, because the seller has filed a complaint against the broker who sent it over. The other one last thing I'll say about this is that up in Washington, they had a similar provision in their contract. Ours started because of copyright, trying not to share these inspection reports left and right. In Washington, they just felt like the seller gave the buyer the right to do the inspections, but not for the benefit of using those inspections against the seller in some really nefarious way, and to kind of set the seller on a bad track where they have to disclose them next time and use it as leverage and in a negative way. I mean, you can always negotiate, but there's a difference. A lot of times these inspection reports are going over to prove that your buyer's being so reasonable, asking for 5 things when there's 50 things wrong, or look at how, look how reasonable I'm being, or you better do business with me because now you got this awful inspection report you're going to have to tell everybody, down the line. So you might as well do some business with me. A new trend also that's happening is asking for $500 in repairs and sending the whole inspection report over and saying, we're rejecting on the entire inspection report, but here's $500 with the repairs that we're asking for. Forms committee is going to be dealing with that issue to see how we need to address it. Because again, it's not, I would argue it's not an exercise of reasonable care. Again, if a seller doesn't think it's substantiated, they can ask for the report, right? They have that right to do so. Anyway, up in Washington, they have a similar provision, but in the Washington purchase agreement, it specifically says that in the event that the buyer sends it over, and it also would include the buyer's broker, because the buyer's brokers are agents up there, not transaction brokers. If the buyer sends it over or the buyer's broker, it constitutes a waiver of the inspection contingency. So I had a long conversation with the attorney for my counterpart up there. I had a long conversation with her. I said, my gosh, weren't brokers getting sued left and right for that? Because they were sending it over, not their buyer, but rather the buyer's broker. And then they were waiving their right to their inspection contingency. So if they want to walk away based on inspections, they were in breach of contract and losing their earnest money. And she said, yep, initially brokerages were writing a lot of earnest money checks. That's exactly what happened. And then it stopped. Because they all got the memo that, if you waive this for your buyer, you're going to be writing earnest money checks. And that's assuming you don't get sued for anything more than that, or that the seller doesn't sue the buyer, because then if they get sued, obviously the buyer's coming after the broker. So really kind of draconian, but that's how they're doing it up there. It's been a topic of conversation at the forms committee level. Quickly, that marijuana is now illegal, and as of April 1st, you're going to see all of the commercial spaces popping up everywhere. The issue of disclosure, what you have to disclose on a property that's been used as a grow house. And the answer is, it's kind of the same whether you're growing marijuana or you're growing, tomatoes. If they've had to turn the property into a grow house for purposes of growing marijuana, then there are going to be issues, right? There are going to be issues dealing with potential issues with mold. There are going to be potential issues with wiring and electric and things that they have to do in order to create this grow house environment. And it can create issues with the property. So if any of that has happened on any kind of level, and I don't have some magic number for you, like 3 plants or 2 plants or 50 plants, if it's happened on any level, it should be disclosed. The Colorado Inspection Services has a growing facility damage checklist, all the things that could be going on in a property that have been used as a grow house. So really, these are the issues you're going to have to be looking at on properties that have been used as grow houses, whether they be residential or commercial facilities. I just want to say that on an adverse material facts form, you guys are going to have to help your clients through this a little bit. You need to give them some guidance. You have to challenge them to think. You have to encourage them to disclose. Our adverse material facts forms, which I've gone over multiple times before, we are doing some work on that form to provide a little more guidance for sellers and a little more assistance in filling that out. But you guys are going to have to help them in the sense that you're going to have to encourage them to really think about issues, right? Really think about things. And I don't want to hear any more lame excuses like I never lived in the home, because that doesn't necessarily mean you don't know anything about the home. Now, maybe you don't, and that's fine. If you don't know anything, that's fine. But this is not a response to, will you fill out an adverse material facts form? No, because I never lived in the home. That's not the issue. these nice people right here working on the home, which maybe they just bought for investment, may have a lot more information about that property than somebody who lived in the home for 20 years because they just tore out all the walls and they did a whole bunch of things to the property. So again, it's not about whether you lived in the home or not lived in the home. It's about what you know. Again, encouraging them to think, challenging them to think, encouraging them to disclose. Very important for your sake, not just their sake, for your sake. We updated some forums. They've been out since last October, but this is the YouTube channel. If you didn't get to see what those look like, I encourage you guys to go there. That's the end of my presentation today. You have questions, call me on the hotline. Don't call me about the appraisal contingency stuff quite yet, because that's still being massaged a little bit. And when that form gets released, I'm going to do an update, a video that you guys can watch. And so if you still have questions after that, feel free to get in touch with me. I just wanted to introduce all of that to you and let you know it's in the works, and that we are working through that right now. Hopefully something will be out in the next week to 2 weeks on that. And that's all I have for you today. Thank you guys so much for hanging in there with me. I know I'm about 10 minutes over. That's not too bad at all. I hope you guys have a wonderful rest of the day and a wonderful weekend.